So we want to land a plane this hour, and hopefully we will. We're going to be talking into a deal for which we don't know things. The Law Society of Kenya has asked questions and is demanding for some documentation. Well, the president of the Law Society of Kenya is one Wakili Charles Kanjama, and he's here with us this morning. A very good morning to you, Wakili.
Good morning.
How are you doing?
Quite well, and happy to be here.
Thank you for being here. Karibu sana.
I hope you're also well.
Salama.
We are well, yes. We just, every time you have to pause because you must check, but we are well. We're going to get into this conversation, a bit of a sticky one, because what really is going on, for which many of us really do not know. So let's find out a little bit about that and go beyond the layers. But before we do that, Dennis this week has traveled to Guinea-Bissau.
Yes.
And there's a proverb that you must interpret.
Yes. Guinea-Bissau. One thing that stands out with Guinea-Bissau is they have hippos that swim in salt water. That stands out. It's also an archipelago. They have 80 islands that makes the country unique to what it is. But the proverb says, a monkey never sees its own backside. A monkey never sees its own backside. How would you interpret it?
This is very similar to the Kiswahili proverb, Nyani haoni kundule,
Yes.
Which means that, some of these monkeys, their backside is very funny, and they start laughing at the backside of the other monkey without realizing they have the same backside. So I think the meaning of the proverb is first look inwards before you accuse or attack others, or even you criticize others. First look inwards. And I think there's also a Christian saying, a biblical saying that first take out the log in your eye so that you can see clearly to take out the splinter in your neighbor's eye. In other words, self-criticism is very important. Let's ensure that the standards we demand of others are standards we are ready to uphold ourselves.
Well said, well interpreted, Asante sana.
Indeed.
Yeah.
Well, let's start with the LSK's concern around this particular matter before we get into the details of what we do know. Now, there is a 375 billion shilling JKIA contract deal for which has been given to a company which leads a consortium of companies. That's the best way that I can put it as to how I have understood it. That it is one company that has been given that, but it belongs to a larger body of companies. Now, LSK wants to understand the details of this, whether it went through a tendering process, if it didn't go through a tendering process, as is required by law for public or state-owned assets and or companies. And the details of this 375 billion shillings and how it arrived at that. So far, so good?
I can give some information.
Please.
First of all, we know that the previous attempt to modernize the airport was the Adani saga, where some parties went to court led by Tony Gashoka. The Law Society of Kenya was also one of the parties that participated in the court case. And Justice Mwamuye gave some court orders stopping a further concession agreement before information was made available about the Adani deal.
Yes.
So the government then chose to withdraw the Adani deal under public pressure without disclosing quite a bit of the details that were being sought. That court case is still pending, and the orders that were issued stopping the Adani project or any other concession agreement are still in place. So after that, in March this year, the relevant ministry floated a tender, a request for proposals, and more than 60 or about 60 individuals representing different organizations participated in the session that was done by the ministry together with the Kenya Airports Authority to clarify on issues of the tender. So what we have heard from our inquiries is that only two companies then put in a bid. This was meant to be an open tender. Now for design construction, it was a design and build tender with some of the financing coming immediately from the Kenya government through the infrastructure bond, some of it coming later on. And the reason why there was only two Kenyan companies, or two companies rather, that put in a tender, despite so many expressing interest, is some of the requirements in the request for proposals were quite onerous. The most significant, which was restrictive, was a requirement saying that for you to qualify to put in a bond, you must have had $100 billion 100 billion shillings or $1 billion project that you've done in Kenya. So you see, you have several companies that are very good in building airports across the world, but they've not built an airport in Kenya or in East Africa because there's not been an airport of that level being built. So, of course, they were not able to qualify, and the only companies that qualified are the ones that have done significant infrastructure projects in Kenya, which are the two Chinese companies, and one of them then was given the tender. So we are saying that there is the appearance of following the procedure, but as the Law Society of Kenya, we are asking for several things. We want to understand several things. First of all, the process that has been undertaken, is it one that is covered by the court order in the Adani case? Of course, the Adani case was talking about concession agreement. This one is titled differently, but we want to understand that. Number two, we want to understand whether there has been public participation, even in the process of coming up with the requirements in the request for proposals, which were a bit restrictive. And number three, just like in the Adani case, and as even Senator Mtata asked in regard to the SGR, the Standard Gauge Railway, and the Nairobi Expressway, we need transparency. In other words, we need to see a copy of the contract that is being entered into, so that there is relevant public participation. And in case any Kenyan is concerned about the way the procurement has been done, they can then have access to the courts or the Public Procurement Review Board or whatever other avenue there is to question it. Having said that, it is also important that we know that JKIA is in a very serious need of upgrade. In fact, you travel across the region, you find the airports of our neighbors are getting better and better, and ours is still stuck in very poor shape. So we all want to get a new airport. We want to get expanded facilities. We want Kenya to become a real hub for the region. What we are saying is that as we do so, can we ensure that we do it transparently, above board, and there is value for money for the Kenyan?
Okay, the awarding of these, rather the floating of the tender and awarding of the same to individuals, it's, as much as it's a development thing, it is equally backed by the law and procedures that are stipulated within our laws, where public participation is not a suggestion, it's a must that Kenyans must be involved, stakeholders must be involved in this process. That there is already a matter in court that where Kenyans are demanding transparency. Kenyans are demanding we see the contract, and that while offering these new contract or awarding these to an individual, you still do that which a Kenyan is in court for. Why? I mean, from where you sit, is it by design that the requirements of the law are things that seemingly is not important for the government to follow?
We've had a dialogue with the government and including the judiciary through various court cases on the importance of public participation. And in the past, the judiciary has struck down several actions of the executive and even of parliament on the basis of lack of public participation. And they have established several principles. Of course, as lawyers, we are a bit disappointed about 2 or 3 more recent decisions of the judiciary that seem to have lowered the standard again of public participation, which is a constitutional value. It's found in Article 10 of the Constitution and several other places. And of course, the media is a very important stakeholder in this issue, because when the information is availed, then you publish as the media, and Kenyans can see and interact with it. So when even the media is questioning, they are not aware of some of the details, you're just given half information, then Kenyans also are less informed. There is a problem. And our constitution is very clear in Article 31, and 35. Article 35 is the one that talks about access to information. And the government used to rely on Article 31, right to privacy. And the courts have said that right to privacy cannot be used to hide information that is necessary for Kenyans to exercise their fundamental rights and freedoms, and also for them to engage in good governance. So there's always a tendency of the executive to be a bit secretive, because this old idea of official secrets, official records, is very strong even within them. And unfortunately, it is in secrecy that corruption, misconduct tends to thrive.
And are we seeing that could be a possibility here? And is that why there is a demand to say, make the documentation available so that we can actually see the process that this went through to arrive where we are?
You remember many years back when Safaricom was floated and privatized, and it was acquired by Vodafone. We remember we were told that now Safaricom has been privatized, it's going to work well, and indeed it worked well. And it took a few months, and then we heard there was a local company called Mobitelea, which had taken 10% of the shareholding. They had entered into a deal with the foreign company that had come in, and they had taken 10%. And we were wondering, who are the owners of this company? And we were being told that the owners of this company might be related to Moi and Biwott Telecom East Africa. So that was a way in which it seemed that a percentage of a public project was being acquired by public officials contrary to our laws on anti-corruption and so on. So it's what is called influence peddling. So we also want to be very careful and clear that there is no such arrangements that are in place, and that is why we need to see all the documents in this place. When you don't see the documents, the transaction documents, everything, those are the situations where you are likely to find deals that have been reached that increase the cost of project 10%, 20%. This, I'm not saying has happened. I'm saying these are the risks that can be resolved once you have full disclosure of the relevant documents. And there have been recent court cases that have said under the Access to Information Act, the Fair Administrative Action Act, governments organs are meant to disclose contract documents to the public.
Okay, so that's my next question, actually, interestingly enough, was going to be that is there a requirement for full disclosure without the pursuit of the same by a party after the process?
Yes, actually, I was involved in a recent case. I've been acting for a party in a case involving the Rirutangong railway. And again, in that particular case, some of the residents of that area, Karen Langata Association, have been complaining that, you see, government has started a meter gauge railway project there, and they did not disclose documents to us. They are meant to do feasibility study, pre-feasibility study. They are meant to do serious public participation before they determine everything about the project. And all these documents under the law are meant to be disclosed. So we're able to persuade the court by showing them the relevant provisions of the Access to Information Act and the Fair Administrative Action Act that require disclosure by the government. And the court issued a court order saying that the project has to stop until the disclosure takes place. And now we are waiting for the final determination of that application. What I'm basically trying to say is that there is a legal requirement for disclosure. And if the disclosure is not done after you make a formal request, one can approach the court, and the court can even stop the project if the court is convinced that the disclosure has not been made. So we are asking the relevant agencies, do the disclosure. If they don't do the disclosure pursuant to the public request, you are going to do the formal demand for the full disclosure. And if they do not respond to that one, then we'll have no alternative but to enforce it through the judiciary.
Wakil, in your opening submissions, there's something you said that is very critical, that Kenya needs a new airport.
Yes.
Because it is old. If you go to other countries, you see the development they're putting into the same.
Yes.
Now, The government has consistently told us that we need a new airport. I mean, there is a time we hosted here a captain, and he told us that there's a time a project started at the airport, but it stopped for some weird reason.
Yes.
They even dug holes, and they've stayed there for almost 10 years
Yes.
now. As the government continues with the cat and mouse, hide and seek games of not disclosing these papers, we are delaying the process that we urgently need. We are delaying the process of having the airport. So it is counterproductive for the government to tell us then that we need an airport. But for you to have an airport, the law must be followed. Would one be correct in saying that we are delaying in having that airport construction kick off because you refuse to play by the rules?
Yes, in fact, it's quite unfortunate. Our airport is fairly dilapidated. It is below the standard it should have. You visit the airports just of our region, neighboring countries, and you come back to Kenya and you feel a bit discouraged, if not depressed, at the state of our airport. So it has been a need for the last 10 years. Previous attempts have failed because they have not been done in accordance with the law in terms of the procedure and sometimes substantive aspects of the process. And even for this one, we'll have to scrutinize. Yes, we need an airport, but that doesn't mean we ignore certain clear requirements of the law. And we are not making a conclusion that they have been ignored. We are saying there are some red flags and we need to just check what is happening. And some of it has come from media reporting, including mention of certain individuals that seem to have been involved in certain activities in other countries that have been questioned, seriously questioned. I want to see, are they actually involved in our Kenyan project that we are being told has been awarded to the China construction, CCC company? Is there anyone else involved? Is it clean? Is it above board? Are we sure that the process of public participation has been undertaken? Are we sure that whatever is being done is not going against a court order that dealt with a concession agreement? So there are a number of questions that we need answers to. And then we also need to know that there's value for money in that project.
So this particular case is very interesting because is it every, so there's part 1A and part 1B, is it every public asset case of this nature for which there is a demand for public disclosure, a full disclosure? And then would government not have learned, because this would be the second go at the airport, this particular place. The first one didn't go through because of something in this nature. So why wouldn't they want to say, okay, come on, guys, we're trying this again. It's needed. So we're just going to be above board and here it is. Why wouldn't they want to just be very clear from the get-go that, okay, this is what we're doing. We're above board. We're clean, everything. Why would those two places be mixed up?
First of all, this is not even the second go. There was the Greenfields project. Yes. This might be the third or the fourth go at it. So they have been attempting to do this from the Kibaki days. I think we now have a new constitution. Government should have learned from previous mistakes, and I think they have been learning. The question is, have they learned enough in terms of disclosure? And the disclosure should not just be for this, but for all big projects of the government. And the government did actually promise that they were going to be having full disclosure and open government. Those were some of their campaign promises that they made, that the issue of secret deals is an issue of the past. They even said there was going to be an IT platform where Kenyans could go and get information about tenders and the progress and so on.
I reckon that's not there.
So what is happening is that part of the implementation has failed of the promises that were given to Kenyans. So of course, while Kenyans are interested in all significant projects, the more high value it is, the greater the interest of Kenyans for natural reasons, because there's a greater risk of loss of funds, there's a greater risk of injury to the economy, and to the taxpayer who has to bear the ultimate burden for the project. And that is why we want to know some of these details.
Okay, contracts are legal documents and legally binding.
Yes.
Right? That is what then would would have Kenya commit itself to CCC in terms of if it's a loan, on how much you're paying, at what percent, at what interest, and all those things. And with that, then, because this is a legal contract, there has to be a legal representative who is then advising government on the same. What do you reckon is happening? Is it that advice is not being taken? Is it that others think they're smarter than the law?
No, I know that for a project of this nature, it will need the sign-off of the Attorney General, just because of the stakes of the project.
Yes.
It would need the sign-off of Treasury. It would need the sign-off of a number of government agencies. I cannot speculate on what happens internally. What I know is that the sign-off is required before the project goes through. And I also know that there has been an issue that has arisen as to securitization, the approach of the Kenya government of securitizing future revenue. They have been doing that with petroleum levy, railway development levy, and so on. And even the World Bank and IMF have flagged that issue. And they have said that that attempt to get financing through securitization of future revenue that you expect to get from taxpayers, and then you keep the project off the books of Kenya in terms of issues of debt, GDP ratio, and all those things, that is improper. And of course, there's also a concern which has not yet been tested by the courts. To what extent can a current government commit future revenue or taxes of Kenyans? Because then you are taking away the ability of future governments to reduce taxes. You've already given a contract that is on the basis of us paying a certain tax for the next 10 or 20 years. So those are issues that will need to be tested. But generally, that is what is happening. That so long as you disclose what is happening, not only the price of the contract. There are other very critical clauses, like if there is default in payment by the Kenya government, what is the consequence? You remember there was the deal where we were worried our port was a security. We might lose our port. There are also concerns about when there is an issue, where is the dispute resolution? What are the default or penalty clauses? Do you pay penalty interest? What is the interest rate? So there is so much that Kenyans need to know about these projects if they are being done for value for money, best interests of Kenyans. That's why we need the disclosure.
How legal is a contract if it has been built on an illegality? Say public participation was not there, disclosure has not happened. How legal is that contract? So
the Attorney General is the one who's first of all meant to advise the government about contracts, legal aspects of contracts of this nature through her officers. Then if Kenyans are not satisfied, they feel there have been gaps, we then go to court. Because once the government has entered into the contract, the only one who can stop it is a court of law. So right now we cannot make a statement or a finding because we don't even have all the information. But if we find the red flags have actually materialized, then we'll go to court and ask the court to declare such a contract to be contrary to the law. Right now, we can't say. But if the court finds there was no significant public participation, if the court finds that the tendering process was inadequate because there are only two tenderers, or terms of the request for proposals were unreasonable, or anything else that the court finds is inappropriate, the court can actually cancel a contract or can order the contract to be renegotiated. The judiciary has tremendous power because they are the ones who apply and enforce the constitution and the law. And the government is bound by the law. Yes.
Who is the person? Because it must sit on some. You mentioned the Attorney General, but who is the person then who is supposed to grant the details of this disclosure?
It is a respective agency.
Who are those?
In this particular case, it would be the people entered into the contract. The ministry, I believe it would be the Ministry of Transport, Kenya Aviation Authority, and the person who was entering into the contract, the ones who did the request for proposals, that government agency would be the one to disclose.
Okay. So we've done little bits here and there, but why would they not want to disclose? Why would you have to ask once, twice? Why would any of these interested parties not want to disclose what should be very public information?
Okay, so what I have seen from the past, because I can just say from my experience with the past, one, they fear that public disclosure of contracts of this kind will discourage some third parties to enter into contracts that are useful for the Kenya government. So they always use this argument that, if we disclose the contract, it will have an effect on the way the contract is managed, or we put in place a clause of non-disclosure. And of course, that clause might be contrary to our law, but they put it in place. So they start saying that disclosure is going to breach the contract. But in the process of negotiating the contract, they knew our law. So sometimes they use those kind of arguments. Secondly, I think there's just that inertia and instinct in certain sections of government to have privacy or secrets, or not to disclose too much, because they feel that Kenyans are not able to effectively digest information. They don't trust Kenyans, and the Constitution trusts us to be able to understand the information. So those are the basic reasons that they give. But there's also the fact that sometimes the deal that has been entered into is contrary to the interests of Kenyans. And disclosure will bring out some of those particulars. That sometimes is also a reason why there is a resistance to full disclosure.
We can almost hear it coming off the car vehicles, car tops now, that there is a very public disengagement from the government wanting to develop. Do you understand what I'm saying? That we know already what will come out, that it doesn't really matter what factions. When you ask for such a thing, it will be seen as a stumbling block in the road of development. Would you be expecting such a response from anybody who is on the other end of the insistence on the public disclosure of these issues? That is a response that we've received, even when already? Okay.
Even when you are in court cases pursuing disclosure on some of these projects. That is a kind of response we receive, that this project is in the public interest. These are just a few people who are expressing concern about it. Other countries have developed. So it's like it's used as a canard, or as something to reduce the disclosure that on this side we are showing you a very gleaming new airport or a gleaming new project, and the vision is, wow, fantastic. It's almost as if Kenyans are being told, please allow some violations of the law. If there is a bit of corruption, 10%, 15%, it's okay. At the end of the day, you are getting a really good project. And I think Kenyans have a right to say, yes, we have a right to development, but we also have a right to information, to integrity in management of our projects, and to value for money in the projects. The two things can be concurrent. They can happen at the same time. It shouldn't be an either or.
You see, we need an airport, we agree. In terms of comparing it, one would say we've lagged behind, we've slept on the job for a very long time, but that has to happen in accordance to the law. And with that then, this being a legal contract and the government having its own advisors and the law is being put on the side, there seemingly is deliberate abrogation of the law with hidden reasons as to why that is happening. Yet Kenyans are expected to pay for projects that they are not aware what is in it. Would you reckon it's by design, it's deliberate, that Kenyans are just not being given this information?
I think I have said there is an instinct in certain quarters in government against disclosure. And it has been a fight that has taken place for more than 10 years. If you invite Senator Mtata here one of these days to tell you about his court fight to get disclosure of the SGR contract documents, and how eventually, after he got some orders for disclosure, they disclosed only part of the documents. They never disclosed in full, and how the case went all the way to the Supreme Court. So there is a really strong instinct against disclosure, and I think we have not fully implemented the requirements of the Constitution of Kenya, even though it is 16 years later. So that fight has to go on, because it has to become the normal thing that maybe within 2 weeks of signing the contract, or 3 weeks, you upload it on the website for Kenyans to see. And you can even give some explanatory notes if you think Kenyans will not understand the document, so that they can understand the document. So these are things that need to be done. They are a requirement of our law. They are not being complied with. And I think it is an inertia, because in the old days, you did not need to disclose. So the fact that the new constitution has new demands on access to information, some people still are living in the past approach to government tendering or public contracts. And then, of course, there's something else that has happened, is that in the immediate aftermath of the new constitution, we enacted laws that were robust enough, and there was an attempt at disclosure. But what we've noticed is that there are gradual clawbacks in what the constitution and the laws require. It's almost like, it reminds me of this saying, constant vigilance is a price for liberty. So it is not enough that we got a new constitution on paper. It's not enough that we got a few laws on paper. If you are not constantly vigilant, then even those liberties, those rights that we won under the constitution will start retreating, because they are not being exercised. It's like if you have some muscles that you don't exercise, then the muscles atrophy. And that is what we are trying to avoid. So we are saying precisely a matter like this one of the airport is a good one for us to exercise our muscles of full disclosure, to avoid atrophy of those muscles.
Can you see a connection between those huge projects and the call for full disclosure, whereby there's been an ardent, vivacious call for disclosure, and it has not happened, and something going wrong in those projects? For example, the SGR, which Okiya Mtata is pushing for, we saw that project was bloated by I don't know how many billion shillings. Do we see that there's a problem, that there's a connection, or there's a similar thread between that for which it's being pushed and a problem in the project?
So SGR has resulted in Kenya Railways having losses of tens of billions of shillings annually. So you can see the impact. The Kenyans may enjoy traveling on the SGR passenger, but it is making losses. So you can see the impact down the line. Expressway, as a Nairobi-born and bred person, I would say Expressway has helped to deal with certain traffic issues. But when Expressway contract was being handled, what was the commitment to Parliament and to the people of Nairobi? That the 3-lane highway from the airport to Westlands will not be interfered with. When we travel on that lower road, we find there are sections it has been squeezed into 2 lanes. So you can see there were problems in the implementation. So when we find some people talking about shooting up of Kenya's debt GDP ratio has shot up tremendously. The burden to the taxpayer of having to service all these debts, of course, is a connection. The bigger the project, the bigger the impact on the public debt of the country. So we want to ensure that for future generations, even for ourselves, we take care of our resources effectively. And that is why there is, as you have indicated, a connection between sometimes the rushed implementation of some of these big projects and future problems that we have to live with down the road.
Is it possible that a project of this nature has already begun, even while the LSK is asking for full disclosure, when Kenyans are saying, hang on, what's going on? Has paperwork been signed? We saw that there was some paperwork that was signed with Adani, even Greenstead, before that.
The Greenfields
project. that was done. There was paperwork already signed. Somebody's signature was already somewhere. So it's very clear that somebody's already taken responsibility. That's what you do when you put your signature down. Is it possible that this has already gone on and folks are just carrying on with their duty and you can, do what you need to do over there, but we have to get this thing done?
Yeah, so fortunately, when contracts are signed, that is when now you have a document to be disclosed to the public. You understand?
Yeah.
And that is when now you can go to court to challenge that document. So there's no problem if they sign the contract after the period of award, because when you award a tender, there's normally a period of about 14 to 21 days when you check whether any of the tenderers has gone to the public procurement review board. If they haven't, and you do the final negotiation, you sign the contract. So they maybe have signed the contract in accordance with the procedure. That one I can't tell. You'll have to invite them here to your studio to tell you how far the project has gone. For us, you're saying disclose how far you're gone with this project, and the moment the contract is signed, disclose it to us so that we can also review it.
And is there an or else? I'm sorry, Dennis. Is there an or else? Do this or else?
Yeah. I think, as I said before, Kenyans have gone to court and have been able to pose many projects. Even recently, the Ebola containment facility that was being put up in Lodwar, the contract had been signed. But we got a court order. The Law Society of Kenya and Katiba Institute went to court. We got a court order on that issue. The Riruta-Ngong meter gauge railway, there is currently a court order on that issue. So projects can be signed, they can even try to start them, but the court always has the power to stop it. The earlier you stop it, the better, because then there's less expenditure of public funds. And we hope that the Attorney General is able to ensure that the contract clauses include force majeure. It's called force majeure. So that if a Kenyan court stops the project, then we don't expose the government to too much penalty, financial penalty in such a project. But even if there was going to be a penalty, there's something called the sunk cost fallacy, and I've talked about it before. The fact that you, for example, sunk a bit of money into a project doesn't mean you continue with it if it is not going to be for the best interest of Kenyans. So you still make a new analysis at whatever stage you are at. Is it okay for us to continue with this project? It's like you can dig a well or a borehole, you drill, you reach the depth required, there's no water. You drill again, there's no water. It doesn't mean you have to keep drilling until the center of the earth. Sometimes you abandon one project and you go to the next one. The moment it becomes too costly or you realize it is not contrary to the law. So the ability to reverse what has been done is there under the Constitution.
But Kenyans should therefore not be seen as people who are opposing projects. That when Kenyans demand for disclosure of these contracts, that when Kenyans demand for public participation, for them to know exactly what it is they will be paying for, because it is them who will be paying for that, they should not be seen as individuals who are opposing development as many would want to look at it, because it is through non-disclosure that Kenyans have lost trust in any other project that is happening, because they're asking case in point SGR, bloated expenses that Kenyans are paying for today. So the government should not look at Kenyans as them opposing, but that they should just play by the rules and things will just sail through.
The truth is, and this I'll speak very delicately,
yes,
that many of our neighboring countries that are doing a lot of development, they don't have the levels of disclosure that we have in Kenya.
Yes.
In some of them, the development is almost dictatorial. The leader just decides on his own. The project comes up, and they are doing sometimes amazing things. Like if you go to Ethiopia and you see what is happening, the transformation of Addis Ababa and other cities, it's amazing. If you go to Rwanda, you see the transformation that is taking place is amazing. In the time of Magufuli, you go to Tanzania and you see how he was just by forcing development. It was amazing. So sometimes you can use that system. Even when we admire a country like Singapore, when Lee Kuan Yew was pushing the development, he was not doing development with a lot of democracy. Democracy was much less, and development much more. Of course, there was an element of democracy. So it is possible to have strong man approach to development, where you just push it and you have to place your trust that the strong man wants to do things for the interests of the country. And if they make a lot of money in the process of development, you can't do or say anything about it. But there's the other model, and that is a model Kenya has chosen to follow. That is a model of development that has been undertaken in Europe, in the United States of America. It is development that is moving alongside a democratic space and full democratic space. That's the kind that we have chosen. That is our constitutional model. And so we have to keep true to it and not be told that we have to sacrifice our democratic rights or public participation for the strongman approach to development. We've chosen the democratic approach. There are very good countries that are role models that have followed that approach successfully, and we also can follow that approach.
So a couple of weeks ago, the CS Health made a statement in Parliament, essentially pointing to the position that they didn't have to ask Kenyan citizens for permission to do anything. And if that is the position that somebody who is in the executive, because that's what cabinet is to a certain extent, could that be something that applies then across board to point to the question of, is there anything of a public nature in Kenya that is bound by the strings of secrecy, that it is not bound by this law where you said it must be disclosed publicly? Is there anything, save for some defense or protection of boundaries and things like that, but is there any kind of project that the government would go into that then is not bound by these disclosure that we speak of?
Okay, so there is the Official Secrets Act, and the courts have on some occasions upheld provisions of this law. For example, when there is negotiation or things are going on, then you should not disclose. The final outcome may be what you disclose, but not internal discussions or deliberations. Of course, there are also issues of national security, whereby issues of security and so on, sometimes the level of disclosure is a bit less, but the level of accountability is not meant to reduce. So, and we have a system of checks and balances. Unfortunately, the legislature sometimes has become complicit in allowing the executive to get away because their power of oversight, sometimes they're even washing it or wishing it away. For example, this privatization law, whereby now they are allowing the executive to privatize state corporations without seeking their consent in each and every one of those cases on a case-by-case basis. You see, that is the legislature failing in its duty. Sometimes it could be the judiciary which issues a decision that fails in its duty to interpret the constitution in a robust way. Then you have other organs and agencies like Controller of Budget, like Auditor General. So there are actually several institutional arrangements to secure disclosure and sufficient oversight. But as I said before, that constant vigilance is a price for liberty. If we relax, if we don't exercise those powers that we've been given by the Constitution and the law, then they will just dissipate and we'll leave ourselves in a situation where a government is a black box. Whatever happens inside, you don't know. The only thing
until
you
it
know
crashes
is you see the project that has come up, but everything else, black box. And that is not the spirit or even the text of our Constitution.
I mean, you've brought in the legislature as a very integral part of it because they are the representatives of the people. They are the ones who then through various committees that would be able to interrogate, say if it's roads, Ministry of Roads and the contracts under the Ministry of Roads, then they are the ones who should be able to ask for these documents, go through them and perhaps even disclose. Are we looking at Parliament that has forgotten its job or has become complicit of the abrogation of the law?
There is a saying that democracy dies in darkness. And black box, darkness is the same thing.
Yeah.
If there is no light to illumine what is happening, democracy starts dying. Parliament actually is very privileged. They get access to a lot of information, some of it confidential, some of it they disclose, and some they fail to disclose. And Parliament sometimes also has a very close relationship with the executive. So if we find, like in this project of the airport, that there has been lack of full disclosure, Parliament also would have to take part of the blame, because they have tremendous powers to summon a minister, to summon any government agency, to insist on disclosure of documents, and we hope they will robustly implement their oversight role in regard to the airport procurement project, even as we look forward to getting a new airport that is up to world standards.
Well, you know, there's the law and there's the insistence on following the law, and then there are consequences, well, according to the paper, of what should happen should you not follow the law. But then in the more subjective, there's also what you feel when you look at a situation from historical happenings, from just the way you feel or what you think. So, Wakili, do you think there is going to be a disclosure of the details of this contract for the airport?
Because I'm not a prophet,
Well.
I'll not give a prediction. What I can say is that for us as a Law Society of Kenya, we are going to be very keen on pursuing full disclosure in accordance with the Constitution and the law. And we will work with the media, we'll work with any government agencies that have the duty and the power to get that disclosure to Kenyans.
So what you're saying is that there is going to be disclosure, or there will be disclosure?
We are going to fight for disclosure,
Yeah.
but you see, we cannot put a gun on someone's head. At the end of the day, the most coercive means we have is a court order. So whatever we need to do, we will work on, but we don't have the power individually. We have to work with other agencies, and that is what I'm saying. We'll do our best on our part, and we hope the other agencies cooperate.
Yeah. Okay, well, it's going to be interesting times, especially seeing as some of the other public issues for which the same thing is being sought have been wrapped up in the courts for a minute, and that folks are still waiting for that, for the outcome of that to be. Do you think that they would take advantage of that and say, well, this one is still over there and nobody's done anything, so we can play out on this for a while?
I think the government has been beaten on the issue of Adani. There was a conservatory order, and once beaten, we hope twice shy.
We hope.
So I think the judiciary has also shown its teeth in some cases, because one of the big powers of judiciary is to issue a conservatory order to stop a project if it is not consistent with the law. So if disclosure results in the project being stalled, then that would be quite unfortunate, and the executive will be only to blame if we get to that situation.
It's President of the Law Society of Kenya, Charles Kanjama. Thank you very much for joining us this morning. One to watch, another one to watch this morning. But thank you very much for being here.
It's been a pleasure. Thank you for inviting me, and have a good day.
Cheers to you too. Good morning.
This is the Situation Room, the only way to start your day.